Uh-huh.
This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this on ethics that includes evidence and procedure.
What happens when a defendant brings an attorney general who isn't even allowed to practice law? He believed one jurisdiction argument could erase every traffic charge. Instead, the judge dismantled every sovereign citizen claim with facts, patience, and decades of legal experience. Watch how confidence collapses when courtroom reality takes music over. Welcome to Verdict Files, where we break down the courtroom moments that prove one simple truth. The law awards facts, procedure, and respect, not internet legal theories. Let's step inside today's courtroom.
All right, DeMarcus Cantrell Brown.
Your Honor, we were representing him, but we are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
aka Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
Not right now. I'm seeking counsel.
Yeah, I'm not buying that for a second. As you'll see in just a minute, he's already managed to find someone willing to play attorney. And judging by what follows, it looks more like a gathering of internet legal experts than licensed professionals.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too.
No, that's not how court procedure works. The deputy only has to appear if one of the parties properly subpoenas them as a witness. If you want to question someone during trial, it's your responsibility to make sure they're legally required to be there.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay?
Okay. I got you.
All right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you.
Court cannot confer jurisdiction.
Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have...
Wait. You see this book right?
Oh, the judge just pulled out law book. Something tells me this hearing is about to get a whole lot more confusing for someone who's been relying entirely on sovereign citizen websites.
This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not
books. Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offense.
What still amazes me is how sovereign citizens are willing to spend thousands of dollars on fines, risk jail time, and waste countless hours arguing in court. All to avoid following rules that would have been much cheaper and music much easier to comply with in the first place. Logic never really seems to be part of the plan.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So all right? It's not a difference between public and private for the record. There's no difference.
Sir, get an attorney.
Okay, all right. January 5th.
Yes, sir.
Okay.
And Mr. Bay / Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them.
Got him.
So first of all,
right here.
The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m.
All right. That's the end of the first hearing. Now, we get to the interesting part. He comes back with his self-appointed Attorney General, who somehow manages to make the hearing even more chaotic. And yes, bringing weapons into what was supposed to be a Zoom court appearance certainly wasn't the brilliant legal strategy they seemed to think it was. Let's see how this decision works out for them.
So, DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
If the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to stay and participate.
Well, I think it's safe to say this isn't exactly one of history's greatest legal masterminds. Every time he opens his mouth, he somehow makes his own position even harder to defend. Clip 8. I'm really not convinced letting someone who looks like they wandered out of an action movie start arguing your case is going to improve your odds.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on, let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay.
Oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off.
I'm really not convinced letting someone who looks like they wandered out of an action movie start arguing your case is going to improve your odds. Then again, considering everything you've already said yourself, there probably isn't much damage left for anyone else to do.
What's going on is he's a member of a foreign state corporation, basically doing business in Georgia. So
Okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying,
sir.
man.
No, and I get what you're saying, but we're not doing
I
that
know,
because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you
We
on
understand
the
the rules of
calendar.
the court. We understand the rules of the court. I got you.
Okay, are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
What I'm trying
no,
to realize
then
he's doing business
as
way
he
in
can
Georgia,
represent
and that
himself.
you need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia, but he cannot have you represent him or purport to represent him, okay? That's not gonna work. All right, so Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
that would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object. You cannot practice law from the...
Well, technically the court could accept a guilty plea if that's the direction the defendant chooses, but that's not where any criminal case starts. Every defendant begins with a presumption of innocence. And it's the prosecution's job to prove guilt beyond a reasonable doubt before any conviction can happen.
Violation on USC 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
I object.
All right, sir. Thank you. You'll get notice in the mail if anything changes about your if anything changes about your address, then you can go ahead and let us know by coming in.
I demand evidence hearing.
You will have that at the time of the trial,
evidence
sir.
hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
you are dishonorable. I got your oath, Tammy Long. Hey.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present.
Object.
Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time. All right, Kevin Jermaine Burrow.
This hearing wasn't about whether someone could question the legal system. It was about whether personal legal theories could replace established law and courtroom procedure. The judge gave the defendant multiple chances to obtain proper legal counsel, explained the law patiently, and even clarified his constitutional rights. From the courtroom, arguments succeed because they're supported by law, not because they're repeated the loudest. Do you think the judge showed enough patience by explaining the law multiple times, or should she have ended the jurisdiction debate much sooner? Let us know your thoughts in the comments. If you enjoy courtroom breakdowns, where judges separate legal facts from internet myths, subscribe to Verdict Files, leave a like and turn on notifications so you never miss another court analysis. Music.